Good afternoon, everybody. My name is David Wheaton, and I want to welcome you to LDF's Opening Doors Fair Housing and Second Chance programs. I'm just going to give a quick introduction of how today's webinar will go, and then I am going to kick it off to our Director of Policy to give an official welcome. But first, just wanted to explain who LDF is. So LDF, or the Legal Defense Fund, was founded in 1940 by Thurgood Marshall. We are the preeminent legal organization fighting for racial justice. We are a nonpartisan organization as well. And LDF has four main pillars that we work under. One is the economic justice pillar, where our fair housing work falls into. We also have our political participation portfolio and pillar, where our voting rights work goes into. We also have our criminal justice reform portfolio, our pillar, and then we also have our educational equity pillar as well. And so just also want to go through some of the flow of the webinar. Again, we're going to have a welcome by our Director of Policy, Demetria McCain. Then we're going to talk about some of the today's challenges under the current administration by Amalia Smirniotopoulos, who is a Senior Policy Counsel at LDF. And then we're going to have a brief introduction of a film called Roofless, a Housing Crisis in America, that was done by Barbara. And then we are then going to have a panel discussion on that film. And then we're going to follow that up with some Q&A. And so folks, you will be able to see that you will be able to leave some questions or any comments within. There should be a section for you to submit any questions and comments. And then we're going to have a case update. As many folks know, there were some whistleblowers at HUD that filed a case against HUD for their lack of enforcement efforts. And so we're going to have an update on that case. And then we may have an announcement by our Thurgood Marshall Institute, which is our research hub at LDF. And then we're going to have a closing and some final remarks again by our Director of Policy, Demetria McCain. And so with that, please, again, let us know if you have any questions. You could please put them in the chat. And with that, I am going to turn it over to Demetria McCain, who is our Director of Policy.
Thank you so much, David. Well, welcome everyone on the actual birth date of the Fair Housing Act, April 11th. Listen, the Legal Defense Fund, as David mentioned, has been fighting civil rights and fighting for racial justice for years. We are a 501c3 nonpartisan organization, so I want to make that clear. And we have been very well known for our successful litigation of the Brown versus Board of Education case, but as well as other work we've been doing across the many years on things like voting rights. I mean, in fact, the current Calais versus Louisiana case, which our President and Director of Counsel, Janae Nelson, recently argued before the Supreme Court, actually is awaiting a decision as we speak. And so, although that case focuses on lines made in Louisiana that determine who folks in Louisiana get to vote for, that particular case, the Calais case, is really about Section 2 of the Federal Voting Rights Act, which could impact all of us across the country in ways that could ultimately impact fair housing rights and many other protections that, while not perfect, have actually assisted Black communities in gaining access to opportunities that would not have been available otherwise, or either other programs or discrimination laws have helped us in very many ways. In fact, it was LDF's case called Shelley versus Kramer that made it illegal for state courts to enforce racially restrictive covenants. Now, racially restrictive covenants were placed in deeds forbidding homeowners from selling their homes to Black residents, to Hispanic residents, Asian American residents, Jewish residents, basically unfavored populations out of certain neighborhoods. So they couldn't sell their homes in certain neighborhoods because of these deeds, these restrictive covenants placed on these deeds. Now, at that time, and I'm talking about 1948, the US Supreme Court said that enforcement of these racially restrictive covenants in state courts would violate the Equal Protection Clause of the 14th Amendment of the Constitution. And that's what the Supreme Court back then said. Well, let's breathe, Because today we are seeing the Constitution's 14th Amendment being challenged by President Trump's executive order. Just to think that birthright citizenship, right? That's part of the 14th Amendment. To think that birthright citizenship, which has been debated way back in the 1800s, would even be in question, let alone a topic that the Supreme Court even needs to address, well, that's really hard to believe. And well, that's a case that LDF is fighting. But at the end of the day, it shows us that while things aren't perfect with our fair housing rights, with other civil rights, these laws and policies we've taken for granted in some measure, but they're threatened today, even if we've taken them for granted. And so at the end of the day, who is in control of our three branches of government is huge. And so our voting rights, our housing rights, our employment rights, our education rights, all of these things are subject to being harmed and threatened based on who is in control of our three branches of government. And let me just say that it was Lyndon B. Johnson who was serving as president when the Fair Housing Act was passed in 1968. Congress passed it, President Johnson signed it, but let's be clear, it was the work of people in the community that made it happen. In fact, community organizers, residents, Reverend Dr. Martin Luther King Jr., and others had been pushing for the Fair Housing Act for many years, but Congress wouldn't pass it. The Fair Housing Act is often the forgotten statute out of all of the Civil Rights Acts. But Dr. King was assassinated on April 7th, 1968. And that followed what we saw as uprisings after his assassination. Uprisings in the streets all across the country. And in an effort to quell the uprisings, because they were taking place all over the place, the Fair Housing Act, crafted by Senators Mondale and Senator Brooks, was finally adopted 7 days later on April 11, 1968, exactly 58 years from today. And since that time, people and groups who have faced housing discrimination have used the Fair Housing Act to either go directly to court to vindicate their rights, or they've used administrative procedures and filed complaints with HUD for free to have their problems investigated and addressed by the staff in HUD's Office of Fair Housing and Equal Opportunity, or some call it FHEO. Now, housing industry professionals, including landlords and developers, they have also used FHEO to settle disputes when they have been accused of violations. And FHEO has worked to help monitor public housing agencies and other entities that receive HUD money to see if they actually are abiding by the Fair Housing Act and other civil rights laws and obligations. So there is a whole lot that HUD's Office of Fair Housing and Equal Opportunity has been known to do, all because community members like you made their voices heard and got a Fair Housing Act and other civil rights laws passed so that they could fight discrimination. And so we've got a great hour ahead of you. And with that, I am going to turn it over to my colleague, Amalia. Thanks for being here.
All right, thank you, Demetria, and thank you everyone for taking some time on your Saturday afternoon to learn a little bit more about this important issue. So as some folks may know, the Trump administration has taken a number of actions to make it harder to access housing, particularly for people of color and individuals who are just as involved. I'm going to talk about three kinds of actions by the Trump administration that will impact individuals who are just as involved in particular: executive orders, lack of enforcement, and rollback of rules and guidance. But first, I want to ground us in how the Fair Housing Act protects people from discrimination. Whether and how and where someone can rent or buy a place to live can be affected not just by overt exclusions, but by policies that appear neutral, but erect invisible barriers blocking Black people and other people of color, women, people with disabilities, families, and other groups from housing. For that reason, the Fair Housing Act prohibits not just explicitly discriminatory actions, but policies and practices that disproportionately exclude particular groups for no good reason, what lawyers call disparate impact discrimination. Take criminal history exclusions, for example. Many landlords and other housing providers, as folks here may know, exclude tenants based on prior criminal legal contact. Because of the disproportionate targeting of communities of color by the criminal legal system and the consequences that are disproportionately imposed on people of color in that system, these exclusions tend to exclude far more Black and Latino people than other groups. Yet there isn't actually good evidence that prior criminal legal contact predicts whether someone will be a good tenant. For this reason, HUD in 2016 issued guidance explaining how overbroad criminal history exclusions violate the law. HUD advised that housing providers should not exclude tenants based on an arrest alone or rely on blanket bans on prior criminal legal contact. And they should also consider conducting individualized assessments based on the nature, severity, and recency of criminal conduct, and allow people to provide evidence of rehabilitation and other factors. Unfortunately, the Trump administration is working to undermine these core legal protections and make it harder for people who are just as involved to access housing. So first, I want to talk a little bit about some of those executive orders I mentioned. In April 2025, President Trump issued an executive order directing federal agencies to roll back rules protecting people against disparate impact discrimination, and also directing federal agencies to challenge state and local laws that offer those protections. In July 2025, President Trump also issued an executive order designed to increase the policing and institutionalization of people who are unhoused, and to pressure state and local governments, nonprofits, and other service providers to rely on these costly and punitive methods instead of proven strategies to reduce homelessness, like housing first programs that offer unconditional, affordable housing options alongside voluntary supports. The Trump administration has also stopped enforcing protections against disparate impact discrimination. While the Fair Housing Act requires HUD to investigate housing discrimination complaints, in August 2025, that agency dismissed several cases and settlement agreements that included disparate impact discrimination claims. The agency also directed its fair housing enforcement staff to no longer investigate policies and practices with disparate impacts going forward. Finally, the Trump administration has rescinded numerous guidance documents that explained how housing providers could avoid disparate impact discrimination, including HUD's criminal history guidance from 2016 and more recent guidance on tenant screenings. HUD also issued new guidance stating that it will no longer reimburse state and local fair housing agencies for investigating disparate impact discrimination, including overly broad criminal history restrictions, and adding additional restrictions as a condition of that funding. And it has also gone so far as to propose removing its own regulations, outlining how it will assess disparate impact discrimination. And we are waiting for a final rule from the agency in the coming weeks and months. But while all of this is happening, communities are fighting back against the Trump administration's rollbacks. As we may talk about a little bit more later, states are strengthening their protections against housing discrimination, passing laws forbidding policies with unjustified discriminatory effects, disparate impact discrimination, in other words, and prohibiting landlords from excluding tenants based on overbroad criminal history restrictions. Moreover, a coalition of attorneys general from 16 states recently sued HUD, challenging the agency's guidance prohibiting state and local fair housing agencies from pursuing disparate impact discrimination claims, as well as those additional unlawful new conditions on fair housing investigation funding. So with that brief summary, I'm going to pass it back to David for the next portion of the program.
All right, thank you so much, Demetria, for that great opening and welcome. And then thank you so much to Amalia for giving us a good synopsis of where we are in the current landscape. So next, we are going to watch a clip from a documentary called Roofless, Housing Crisis in America, which is a 2020 documentary explaining systematic housing insecurity, unfair practices for marginalized groups, and the devaluation of homes in Black and Hispanic neighborhoods. The film highlights how the U.S. housing crisis stems from a supply shortage, rising costs, and policy failures, which impact renters and first-time home buyers. And this clip that we're going to watch is going to deal explicitly with reentry policy as well. And so with that, we'll go ahead and start and play the clip.
When things go wrong in Black communities, we blame Black people. My favorite saying that really captured that comes from a Vietnamese philosopher, Thich Thich Nhat, who once said, if you're growing a head of lettuce and it's not growing, you don't blame the lettuce. You see if the soil is enriched. You see if it's getting sunlight, if it's getting proper rainwater. You never blame the lettuce. But when things go wrong in Black communities, we blame the lettuce.
According to HUD's 2016 Criminal Records Guidance, 100 million U.S. adults, or nearly 1/3 of the population, have some sort of criminal record. African American and Hispanics are arrested, convicted, and incarcerated at higher rates. Therefore, criminal record barriers are likely to have a disproportionate impact on minority home seekers. In some cases, individuals that have an arrest record but have never been convicted also experience difficulty in finding housing due to that arrest record.
Any housing provider that has criminal records or criminal background checks and are enforcing it in a disparate fashion, treating African Americans or Latinos differently than they would treat white applicants, that would clearly be a violation of the law.
But HUD's regulations in place for getting into public housing, staying there, were quite restrictive when it came to people with criminal backgrounds. And, there was the one strike rule, so that if you are a granny and you have 3 grandchildren living with you and one of your grandchildren gets arrested, your whole household could be evicted just on the strength of an arrest. And I always felt that rule was really way overbroad because, first of all, an arrest is not a conviction, for number one, and a lot of people, especially people of color, are arrested without any conviction ever occurring, and also because important because it disempowered the entire household and put the entire household at risk, instead of taking a narrower approach and saying even if someone maybe was convicted of a dastardly crime, that person could be barred from the household and the rest of the household remained. So that case was that situation was way too broad and needed to be addressed. But banning someone from a housing opportunity because they had an arrest, for heaven's sake, or a conviction for a minor crime, or even a conviction for a more significant crime that occurred 20, 30, or 40 years earlier, harms people of color.
There are a number of conundrums that come up when you're coming out of prison. And in prison, they have all these programs, to get ready for this and get you ready for that. But at the end of the day, all that stuff works while you're in prison. Right. The day you leave prison, if you don't have somewhere to go, you're getting off a bus in New York City and you're going to the shelter system. Years ago, if you received a felony, you can't live in public housing. You couldn't be on someone's lease, or not even be on their lease. You just couldn't live there. You couldn't go there. So those problems still exist. Things have changed. Lots of things have changed. And so I think progress is being made. But where someone's going to live, where they're going to work, that still remains a problem. Someone's coming out of prison. They all don't have someone's home to go to. Mother, father, sister, brother, wife, girlfriend. They don't always have that. And then those who do have that could become temporary because now you've changed. You've been in prison for 15 years. You've been in prison for 8 years. And even though he or she or whomever may want you to come live with them, you're a different person.
Housing providers that receive federal financial assistance can no longer arbitrarily deny individual housing because of an arrest record. That housing provider must take into account factors such as the type of crime, the length of time since that particular conviction. In recent years, there has been an increased effort to ease restrictions around housing for formerly incarcerated individuals. In 2017, Ver Institute of Justice, an organization dedicated to end mass incarceration of people of color, immigrants, and people experiencing poverty, launched the Opening Doors to Public Housing initiative to expand access to housing for those who have a criminal record. In 2022, President Biden proclaimed April as Second Chance Month, asserting the importance of helping people who were formerly incarcerated re-enter society. Another initiative to address criminal record housing barriers, U.S. HUD Secretary Marcia Fudge directed her principal leadership to conduct a comprehensive review of HUD regulations, guidance, and policy documents that mention the use of criminal records in tenant screening, selection, and decisions. The review will propose changes to language to help housing providers avoid the overly broad use of criminal records in denying or excluding people from HUD-assisted housing, and make appropriate changes based on those recommendations in review of federal statutes. We should open doors, not shut them. As a nation, we must take a hard look at how we treat formerly incarcerated people that are seeking housing who have repaid their debt to society.
All right, great. So now, yeah, I want to now bring up our panel, if we can, to kind of begin this panel discussion. And on the panel, we're going to have the filmmaker who helped create this film. And so really excited to get the panel started. It also will include Amalia Seminatopoulos, who you also heard from before. All right, got everybody. So Barbara, I really wanted to start with you. So I know you are a former Fair Housing Equal Opportunity employee at HUD, but can you talk about more about why you wanted to make this film? You know, what was your inspiration around this?
Yes, my inspiration really was the need, in my opinion, to really bring awareness to individuals that were formerly incarcerated. Because one of the things that I really looked at was when I was at HUD, we did a lot of awareness training to the housing industry about the criminal background guidance, right, and its initiatives, and getting those individuals up to speed on what the guidance meant, how, what they should be looking at to change in their policies. But then it was really important to me when I left HUD is because it was such an important initiative to really get it out to the masses for those individuals that really are coming out of prison or have been formerly incarcerated. They really weren't aware of the initiative. So I really reached out to a lot of organizations that dealt with reentry and really try to focus on organizations so they could get that information out to those individuals. Because a lot of times when I spoke to individuals that were previously incarcerated or who had arrest record, they were totally unaware that this initiative was out there. So I thought that was really important, and that's why I really focused on that segment in the film.
Thank you so much for that response, Barbara. I want to keep it to you for just a second. Also in the film, you highlight that, again, many people who have been arrested but not been convicted of any crime still struggle to find housing. Can you talk more about the barriers that this creates for people? And do you see these barriers having an impact directly against Black and brown people?
Yeah, absolutely. When you think about it, right, an arrest record is totally different from a conviction, right? But it has the same effect in a lot of instances. So when you think about somebody that may have an arrest record for a speeding ticket or disorderly conduct, right? It's an arrest record, but there wasn't a conviction. So the result can be the same. So an individual that's looking for housing or applies for housing, right, and they have an arrest record, the first thing that they do is they really look up your, they look up your record, right? That's part of the tenant selection, and they pull up your file. And one of the things that's people aren't really aware of is arrest records are permanent. It's a permanent file with law enforcement, right? You can go on public sites and you can find that information. So especially when you're seeking housing and you're doing background checks, it can trigger an automatic rejection just because you have that arrest record, right? But the association to it is really null and void. But again, that impedes a person that's applying for housing. If that arrest record comes up, then the result is they're unable to obtain housing. So that's really imperative. Applicants don't have an opportunity to explain their circumstances a lot of times when there is a rejection, right? It's just, okay. And a lot of times housing providers don't give an explanation. They just say, we're sorry. And so again, that impedes their ability to obtain housing. And so the impact, it can be really significant. It limits access to, so a person that's denied housing, it limits access to a flourishing neighborhood. So when you think about a flourishing neighborhood, just the quality and resources surrounded in that particular community, right? Grocery stores, hospital, parks, restaurants. Those are all contributing factors if somebody is denied an opportunity, right, to have a choice to where they want to live. And the impact is significant because you think of individuals that if you can't get housing, you don't have an address, right? A lot of people that are formerly incarcerated, they're coming out because they're unable to find housing. They wind up in shelters, they wind up homeless, right? If you don't have an address, it impedes your ability to find work, right? A career. So all of those things are really impactful for somebody that doesn't have access or denied because they have an arrest record, but really there's no connection because it wasn't a conviction. But just that having that arrest record, it just denies you an opportunity to actually have access to housing. And so the impact is very far reaching.
Yeah, no, thank you so much for that. One other thing I would just add to that is that also sometimes these tenant screening companies get their arrest record wrong, right? And so if a tenant doesn't have the ability to try to correct that record, a landlord may just deny somebody for an arrest record that's actually not their record, somebody who may have a similar name to them. Amelie, I want to turn it over to you a little bit and kind of give you a question you may not have been expecting, but I just want to kind of throw it over you. LDF has been doing some work in the states. You talked a lot about how states and localities are trying to strengthen what they're doing. Can you talk about some of the work LDF is doing, particularly maybe in states like Maryland or other states that we're trying to work on increasing the state's capacity to strengthen fair housing enforcement?
Yeah, so I think we're pursuing a couple of different strategies there that are actually being led in large part by David, who's been doing amazing work at the state level. So, we are currently trying to advance two different bills in the state of Maryland. One would codify the existing protections in state law that prohibit disparate impact discrimination, that form of discrimination I was talking about in the beginning that prohibits unjustified discriminatory effects, even in a policy that may look neutral on its face. This is a really important bill in this moment because we know the federal government is rolling back its own enforcement. They're trying to roll back their regulations. They have rolled back their guidance. And so making it perfectly clear in black letter statute that Maryland Fair Housing Act prohibits disparate impact discrimination and applies the same standards that the federal government was applying is incredibly important in this moment. That bill also would give additional authority to the state to do regulations on what is called affirmatively furthering fair housing, which is my favorite part of the Fair Housing Act. It is the part of the bill that says not just do we need to avoid discrimination, we actually have to take active steps as a society to remedy residential segregation, increase access to housing opportunities, and ensure that we're undoing the long-standing patterns of segregation that have become baked in to where we live, and then impacting where we learn, the quality of our environments, and everything in our lives. And so this bill in Maryland would empower the state to issue regulations outlining its affirmatively fair housing authorities and what jurisdictions in the state and public housing authorities have to do to take those kinds of actions. As we're seeing rollbacks, again, of those federal level protections in the current moment. We're also looking to pass a bill that would codify limitations on what landlords can consider when they are conducting background checks, and would impose a look back period limiting how far back in time a criminal conviction can be in order for a landlord to be able to consider it. It would limit the kinds of offenses that a landlord can consider. And it would also require landlords to consider evidence of rehabilitation, mitigation, etc., which is essentially taking what HUD did in its 2016 guidance and putting it into practice, making landlords' obligations clear, ensuring that there's no confusion about what they have to do to the extent that there was anything before, and also we hope giving people the tools to try to vindicate those rights in court. So I think while federal law already prohibits overly broad criminal history restrictions, we think that state laws like this are crucial in this moment because of what Barbara was just saying, that landlords are still not following the law. And the more clarity we can provide, the more access to housing people will have.
Yeah, no, that's great. Before I go to the next question, just want to remind people to please put their questions or any comments in the chat. We're going to have a Q&A session right after this, and so please, we want folks to be engaged in this webinar. So please put your questions or your comments in the chat. Amelie, I want to stick with you if that's okay. And I want to talk specifically, I want you to talk about a case called Equal Rights Center versus JAG Management Company, which is a case in DC. Specifically, what were some of the alleged discriminatory practices that landlords were using to block housing opportunities to certain renters, and how did those practices violate the law?
So I think this is another great example of why we need, both federal, state, and local level laws, protections, and guidance, and also strong enforcement to help give those laws and guidance documents life. So this case challenged requirements that a number of property management companies were imposing that unlawfully discriminated based on applicants' source of income, their eviction records, and their prior criminal legal contacts. And in addition to illegal fees or deposits that were required by those property management companies. I'm going to focus particularly on the restrictions on criminal legal contact, and start out by just saying a little bit more about the context. So DC already has a law that provides restrictions on what housing providers can consider when they are evaluating tenants. That law specifically prohibits housing providers from asking about a prospective tenant's criminal history before they make a conditional offer of tenancy, meaning they have to look at all of the other factors that the tenant may have there before they actually run a kind of criminal background check. And then even after a conditional offer is made, the housing providers can't ask about or exclude people unless the prospective tenant has an open case or has been convicted of a short list of serious offenses like aggravated assault and murder, and can only consider those offenses if they've happened within the last 7 years. Now, despite this law, the companies had written policies that didn't actually mention any of these limitations on the criminal records that would be considered, or talk about that, the fact that they would have to look at the tenant's other qualifications before running a criminal background check on them. And what the Equal Rights Center did is they sent in what are called housing testers. So people that, either called the building, called the management company, or went in person to ask about what the policies that were being applied to prospective tenants. And what they found is that when the testers asked about the policies, they were either given ambiguous information that, it was unclear what the policies were and whether the companies were going to consider things like arrests or convictions that were not on the list specified by the DC law, or they were actually told explicitly that the companies were going to consider things that were prohibited by DC law. Mm-hmm. Like when one staff person stated that the management company looked at both not only convictions, but also arrests, and that they didn't have any limitation on the kinds of charges they considered or how recent those charges must be. So the Equal Rights Center took action and they sued the companies for violating DC's housing and consumer protection laws. And on March 12th of this year, they announced a cooperation agreement with the JAG management company to ensure that the fair tenant screening process at the company would actually comply with DC law for all applicants. This is an incredibly important victory, but it also shows, exactly what Barbara was talking about. There's an ongoing need for education and enforcement because what these management companies were doing not only violated DC law, it violated HUD's 2016 guidance because they were telling people that they were going to consider arrests, which HUD made very clear should not be considered as part of a decision about whether to give someone housing. And this was a recent case. It was filed in 2025. So there is a really, really vital need to continue to invest resources to make sure that people know the law and are following it.
Thanks so much for that synopsis, Amalia. And again, want to put out the call. If folks have any questions or comments, please go ahead and put them in the chat. This is for anybody who wants to answer. Despite the efforts over the years to create more economic opportunities for all communities, there remain significant racial and economic disparities in housing opportunities, not just for folks who are formerly incarcerated. As we look to the future, what policies or programs might create more housing opportunities for all communities? Amalia, I'm thinking about what you were just saying about affirmative furthering fair housing. Just want you to, would anybody want to take that, or what type of opportunities or programs that could be enacted to try to create more equal opportunities out there in housing?
I just want to make a comment about that. I think that it's really going to be imperative also is we have to remain vigilant. I know there's a lot of policies and procedures out there, but we have to remain vigilant with respect to what's happening with all these rollbacks with, just within the Fair Housing Act, right? When you think about some of the rollbacks for enforcement initiatives, right, that are extremely important to get cases out, to make the public aware. But it's going to be difficult when you have all these rollbacks with respect to, going after state agencies saying they're not substantially equivalent because of the additional protections. It's just going to be, again, it's going to be really important that we call on our congressmen, we're working with other advocacy groups, right? Because it's a real issue. And right now with this administration, they're really trying to silence and enforcement and really make it impossible or difficult when you bring cases, by ripping away the disparate impact. So those are things that I think, again, you just have to be really focused on and making sure that we're doing what we can to decrease some of these rollbacks that are happening.
Yeah, Amalia, did you want to take a stab at that one as well?
Yeah, I would co-sign everything that Barbara just said and add to that one of the risks is, there is an affordable housing crisis in the country right now. And I think there are lots of legislators at the federal, state, and local level that are looking for solutions to increase housing supply and address some of the barriers that everyone is experiencing. But we also need to be paying attention to the ways in which those investments are being deployed, which communities are actually getting those resources. As we're building new housing, where is it going? Are we ensuring that communities of color have equal access to high quality housing, that they can move to the neighborhoods they want to live in, and that we're also investing in the neighborhoods that they may have deep connections to, so that we're both expanding housing choice and trying to make sure that everyone has access to good quality schools, transportation, and all of the other resources that can make a community thrive. I think that goes to the affirmatively furthering fair housing policy and this enforcement pieces that Barbara was talking about. And there are also, I think, some additional concrete things that we can do to continue to address some of the discriminatory barriers that people are facing. So I talked a little bit about what we were doing in Maryland, but there are other policies that jurisdictions are pursuing, things like eviction ceiling. So requiring that if you have had an eviction filed against you and it has not actually resulted in an order of eviction, or even if it has, if it is old and is no longer relevant in figuring out whether you can pay your rent and otherwise be a good tenant, that is sealed. Landlords don't have access to that information because it's not actually relevant to the decision about whether you're going to be a good tenant at this point in time. Other jurisdictions like New York and Maryland have looked at things like good cause evictions and limiting the kinds of criteria that landlord can base an eviction on. And then there are numerous ways to address barriers to homeownership as well. For example, addressing appraisal bias, down payment programs, and other methods that try to level the playing field and reduce the racial homeownership gap and the racial wealth gap.
Yeah, that's perfect. I've heard when LDF was helping to do some state-based advocacy on that eviction ceiling, there was people who were testifying who says that eviction record is kind of like a scarlet letter sometimes, that, once they get that first eviction filed against them, and sometimes not even, it could be a discriminatory practice by their landlord or try to intimidate them by filing some type of eviction action. But once you have that eviction action on your record, it's kind of like a scarlet letter, and where it's very, very hard for you to obtain housing anywhere else. And so that's really, really important. We've got some questions now that are rolling in. There was just one final question that I have, for both of y'all. And again, this would be for either of y'all who want to answer. There was a really powerful moment in the film when Bernard Brown from the Empowerment Zone was talking about how people who do not have anywhere to go when they leave incarceration, speaking to this, just why is housing so important for people who are justice involved, especially for those who are just getting out of incarceration? Why is housing just so important for them? It seems self-explanatory, but we have policies, unfortunately, that go against that. So why is housing so important for those folks?
I can get this one started, but we welcome Barbara to jump in. I think housing is foundational. If you don't have a safe place to live, it's hard for anything else in your life to come together. You need housing so that you have a place to store your medications, so that you have a place to shower, so that you're ready for work, to store food to eat, to be with your family and loved ones. Without housing, I think it's very hard for us to have, other positive outcomes in our life. And we know from the research that because of the discrimination that we've been talking about, the people who are coming home from incarceration, as well as people that may not have been incarcerated but have been arrested and convicted, those individuals are more likely to experience homelessness. And as a result, it actually means that they are more likely to end up getting caught back up in the criminal legal system because they don't have a stable place to live. I think one of the most frustrating things is, if we actually address some of the criminal history barriers, we would increase public safety by helping people find stability in their lives, and be able to get the supports that all of us need to thrive.
Yeah, and I would also like to say, excuse me, when you look at the totality of it, again, a person doesn't have housing, access, to those vital things, right? The actuality is when you're homeless, you're living on the streets, you can't find work. That really that's a contributing factor to just your overall well-being and health, right? And so then you start to, the depression comes in, right? And we all know the connection between health and well-being, right? If you don't have that health and well-being, then that person start experiencing other health issues. And it's just in its totality, again, just a breakdown of your health and well-being, coming up with other illnesses, but it all relates to and it can be tied back to just the stress of not having a home, the stress of not being able to be employed, right? All of that comes together until the outcome, the result, again, is a person, that their health and well-being is affected.
Yeah, no, both of y'all make really, really great points. So we've got a couple of questions that have rolled in from some folks. So the first question, with all the rollbacks at HUD, should we even bother filing complaints at HUD? I will definitely say yes. And I think there's a few reasons, but, I'll also pass it off to Barbara and Amalia. I think one of the reasons why I think folks should still file complaints for HUD is that we still want that record to show that there is still fair housing issues that are going on across this country. Complaints have actually risen in the last few years, especially complaints regarding folks with disabilities. We also seen racial discrimination complaints also being filed. And so, I do know that there's a lot of rollbacks, but I think we should continue to file, complaints at HUD to ensure that Congress knows, HUD knows that there is still a fair housing issue and fair housing problems and fair housing discrimination going on, unfortunately, in this country. Amalia, Barbara, did y'all have anything else on that one?
Yeah, I'm just going to go back to we still have to be we still have to be, aggressive, right? And in this, because I think, some of these rollbacks, that they really can deter folks, because as some people say, why am I going to file a complaint? Nothing's going to occur. But again, we have to be we have to be aggressive with respect to filing those complaints, because again, the outcome of some of those cases bring awareness, right? The case that Amalia talked about, again, so if you're not filing the cases, we can't get to a resolution and an outcome that can really be significant.
Yeah, I agree with everything that's been said. And I think the only thing I would add is just to underscore that HUD's rollbacks don't change the law.
Exactly.
They are rescinding guidance. They're trying to roll back their regulations. But the Supreme Court has been clear that the Fair Housing Act prohibits disparate impact discrimination. And no federal agency acting on its own can change what the Supreme Court has ruled. And so the law still protects you from these harms. And I agree that we need to be filing complaints and to be holding HUD to account for its refusal to protect people in this country from these discriminatory harms.
No, yeah, and both of y'all make great points. And Amalia, what you just said kind of rolls into our next question from the audience and community members, is, what should I say to a landlord if they deny me based on an old arrest record? If you want to take a stab at that, I can kind of start by saying, we still have, even though HUD has rescinded that 2016 guidance and then the re-upped 2022 or 2023 guidance, the law that guidance was still based on is still good law. Nothing has changed again with the law. And so maybe Amelie, if you want to talk a little bit more about, especially if it's just an arrest record and not even a conviction record, then we really got good, law that says that, hey, an old arrest record that could be really, really problematic if I have a landlord that's denying me because of a very old arrest record. But Amelie, if you want to take a quick stab at that question as well.
Yeah. No, I agree with you, David. Well, one, I think before I go into it, I'm not here to give legal advice. So I'm here to talk about what the state of the law is. And the state of the law is that, HUD said back in 2016 that a denial of housing based on an arrest record alone was unlawful under the Fair Housing Act because there is no arrest is just an allegation. It is not evidence of actual wrongdoing. It should not be the basis of a denial of housing. While that guidance document may have been rescinded, as David was saying, the guidance is important because it is an analysis of the law, but what controls are the cases. And there are still numerous cases out there that have made similar conclusions about what the law prohibits. I think there are also some concrete steps that people can take when they encounter these kinds of barriers. One is to ask for the landlord's policy. And if they have an explicit written policy about what they consider, to ask for a copy of your record so that you can make sure that it's accurate, see what they've been considering, ask to talk about the fact that this is an old record, it's not for a conviction, talk about the HUD guidance. And also, we're talking primarily about federal law because that's what applies most broadly across the country, but there may also be state and local laws that protect you and are even more specific, like the DC law I was talking about a few minutes ago.
Yeah, that's great. And we also had just one more question from the comments and it says, what is the importance of the upcoming midterm elections? How are these issues raised to local, state, and federal politicians so that voters are aware of their stances on these issues? And so again, just want to reiterate that LDF is a nonpartisan organization, but I think you bring up a really, really good point, Dee, I think, who asked this question, is that we really can start to raise these issues. So one, on a local and state level, really start to think about and maybe asking, asking your state and local politicians, about increasing their fair chance at housing legislation, or whether or not their state even has one, right? And so we know what's happening at the federal level and what HUD is doing, but our state and states and localities can really act in these moments to try to be a barrier about what the federal government is doing. And so really talking to your state and local elected leaders to make sure that they are prioritizing these types of protections, these type of fair housing protections for folks who are formerly incarcerated or justice involved. And then, how will you be aware of their stances on these issues? That includes a lot of voter involvement and engagement. We're going to talk a little bit about that towards the end, but going to some town halls, going to some of these places and asking those questions and trying to get their upfront answer about where they stand on these issues. And again, talking about the importance of this. And so thank you so much, Dee, for that. Right now, I also want to introduce one other guest that we have, Leslie from Justice for Housing, which is a grassroots organization in Boston. And they've been doing some great work. Leslie, thank you so much. Thanks so much for joining us, Leslie.
Thank you. Thank you for having me here.
No problem. Oh, go ahead.
Go ahead.
Yeah.
I can touch base on those questions if you want.
Yeah. I'm just going to go ahead and ask you a question that we've already got queued in for you. Again, you've been doing some really amazing work locally in Boston. Leslie, what are some of the policy solutions at the state, local level, or that public housing authorities can enact to help address the lack of federal fair housing compliance to protect the rights of people who are justice involved or may have some type of conviction or arrest record?
Sure. I'm Leslie Creed. I'm founder, Executive Director of Justice for Housing. Thank you for having me. We here in Massachusetts worked directly with public housing authorities. I myself am also formerly incarcerated. And so when I came home, I saw the discriminatory policies that were in place for people with queries or criminal records that were preventing them from housing. And so what we did was we asked a lot of the local housing authorities to change their punitive policies and adopt our HUD rules, which became HUD rules, our Far From Home report. We had 10 policy recommendations, and 6 of them became HUD rules under Marsha Fudge's policy. Since then, we had to resend them and put them off for another later time. But some of those rules were, changing the look back period, changing the preponderance of evidence, like you're innocent until proven guilty, having the same standards as the court of law. Some of the policies that we asked the housing authorities before, they were evicting people just because they were arrested, right? Not even on property. And so we asked them to change some of those policies. And on the national level, we are working on implementing those policies nationwide right now, trying to get all of the other states to come on board and see what works. Housing has been key to a successful reentry here in Massachusetts, and these policies have been, influential in getting people stable, keeping them off of probation, keeping them from reciderating, things like that.
No, that's perfect. Thank you so much for that. And listen, just one, I want to give a plug to a really great program that y'all have with your SHARP program, which provides permanent housing, stabilization, and wraparound services for returning community members. I think that's a really great model. Can you talk a little bit more about that SHARP program and how it has been, a model to kind of help folks who are just reentering after some type of period of incarceration?
Sure. Well, we were the first directly affected organization to partner with public housing authorities. We used our Far From Home report as leverage, and we asked them to change their punitive policies. And one of the policies was to provide us with subsidized or Section 8 vouchers for people returning home from incarceration. And so we partnered with Boston Housing, Cambridge Housing Authority, and got them to, before there was no housing vouchers, there was no pathway for people to come home from parole or probation into public housing. And so this was a means that we used by providing them with subsidies, Section 8 vouchers, along with case management, which is necessary. The mental health, the wraparound services is also needed. But what was really dynamic is we have a holistic approach where we give them subsidy vouchers, but we also stabilize, provide them with workforce development, and then transfer them over to home ownership. So this year we had our first homeowner coming out of the SHARP program and gave back the Section 8 voucher, right? We want people to be sustainable for themselves, not provide on public housing, not provide on, the system all the time. And so this is a way that you can provide something temporary for somebody who needs and coming home and then stabilize. And then once they maintain themselves, reunify with their children. That's another key to this aspect of the housing. A lot of children in foster care because of incarceration, and getting them stable and then become homeowners.
That's amazing. That is such amazing, Leslie, and a really great program. And so I think this has been a really great panel. And now I want to turn it back over to our Director of Policy, Demetria McCain, who's going to introduce our next speaker, who's going to talk a little bit about that HUD whistleblower case that I mentioned at the beginning. But again, thank you so much to our panel. It's been a great discussion.
Thank you.
Wow, thank you so much, Barbara. Thank you so much, Leslie. That was rich. That was really rich. Really appreciate that. And so now I won't be long because I want you to hear directly from Paul Asadebe. He, along with his co-workers, Palmer Heenan, Hannah Gordon, Julia Dijkstra, and others, as well as Ms. Velasquez, they came forth in September 2025. And as staff members of HUD, working in the HUD General Counsel's Office of Fair Housing, which actually helps process the Fair Housing Office's complaints, they filed a whistleblower complaint against HUD for its violations against the Fair Housing Act. And Paul is going to join us and give us an update on what has taken place since September, since filing that complaint. So over to you, Paul.
Thank you so much, Demetria, and good afternoon, everyone. I'm Paul Asadebe. I'm a former worker in the Office of Fair Housing. I was a trial attorney, and in that office, basically, we prosecute complaints of discrimination, and we advise the whole agency on how to actually protect your rights, how to make sure that people aren't being blocked from housing based on prior criminal histories or based on their race, disability, having kids, all of that. And we came forward because we saw that that work was being blocked in a bunch of different ways. And unfortunately, that continues to happen. So one of the things we talked about in the report was reassigning everyone out of the office. So there were a bunch of attorneys in the Office of Fair Housing, and we're the ones who actually, when you file a complaint, we help it get investigated, and we're the ones who prosecute it, or we are the ones who write the guidance that tells public housing authorities or your landlord how they avoid discriminating against you. The administration didn't like us doing that work, so they plan to reassign all of us involuntarily out of that work and to defending the agency. And then they've been able to do that. Since I was terminated for making the whistleblower report, shortly after they did that, they reassigned almost all of the attorneys to defending the agency or doing ethics work, doing everything except protecting your housing rights. And that's really sad. But we, of course, are continuing to fight to get back to protecting your rights. We've seen new policies actually come down. So at around the time of the whistleblower report, there were new restrictions put on the investigative office, FHEO, that's been mentioned, that said that they couldn't investigate many types of cases. So that's anything involving disparate impact, environmental justice, criminal records, anything involving LGBT people, so many different types of cases. They are not allowed to spend any resources working on those cases. We saw new restrictions based on language access. So civil rights laws that we enforce include protections based on national origin and based on functionally the language that people speak. You're supposed to be able to come to HUD and be served in the language that you speak, whether that's English, Chinese, any language. You're supposed to be able to get help, but this administration does not like that. And so they have started restricting the ability of HUD to talk to people in languages other than English, but not just HUD, the organizations that we fund. So your state and local organizations, whether private or public, they're also being pressured not to provide services in languages other than English. They're being pressured not to protect classes that are not in the Federal Fair Housing Act. So, for example, if your state protects you based on your history of involvement with the justice system or based on using vouchers as the way you afford your housing, or based on you being a veteran. The federal government is now saying that they won't pay for those services. And if you try to protect those additional groups of people, we're actually going to take your federal funding away to make sure that you can't do that. And there's so many additional restrictions coming that we thought it was important to tell the American people about what's happening. So this next Tuesday, we're going to be launching a campaign called the Dear America campaign. And this is a campaign of current and former people at HUD and all across the government to just tell the stories about what is actually happening to people's rights and their services in the government. And it'll be through anonymous letters that are posted publicly, just telling people what's happening, how we're being restricted from serving you. And we hope to expand it throughout the federal government and to eventually have people like you, the people that we serve, talk about how you're no longer getting help from HUD, how you're not getting what your tax dollars are paying for anymore. So when that comes out, you can take a look at that at dearamericaletters.org. You'll probably see media stories about that that Tuesday. And part of the reason that we're launching it now is because this is Fair Housing Month. We are at the 58th anniversary of the Fair Housing Act being passed, and so many things are being rolled back and attacked and harmed, and so many people are not getting the protections that they deserve. This was the best time to talk about that. And a great example of that is this this video I'm about to post, which is our secretary, Scott Turner, the one who fired me and the others for whistleblowing, and who's rolling back all of these protections at the insistence of developers and landlords and Trump himself. And that video is his fair housing message. It's his, he talks about how we did too much. We were too aggressive in enforcing fair housing laws. He talks about how enforcing the Fair Housing Act was too woke. It needs to be restricted. But he never talks about you, about how you get your housing, how you get a roof over your head and your rights protected. And so we needed to come out and talk about what's actually going on. So I hope that you will follow that campaign and continue to talk to your state, local, federal officials about how you need fair housing enforcement. You need the ability to live where you want to live, to get that job that you want, to be in the school district that you want, and to just live the life that you want. That can only happen if everyone has equal access to housing, and that's not going to happen without enforcement. So with that, I'll turn it back to LDF, and thank you for allowing me to give you this update.
Great. Thank you, Paul. Thank you for your courage along with your colleagues in speaking out. It's disturbing to hear what's happening inside of HUD, but incredibly important that the message is getting out there. I'm just going to briefly flag a forthcoming report by my colleagues at LDF's Thurgood Marshall Institute, which is our in-house research and think tank. They've done amazing work before on looking at discriminatory criminal history restrictions in employment and in housing. And in the coming weeks, they're going to be coming out with a new report, Locked Up, Locked Out, the Racialized Cycle of Criminalization and Homelessness. This report will walk you through the ways in which the criminal legal system, housing exclusions, and other discriminatory policies create a cycle that traps people in the criminal legal system and forces them into homelessness. From the ways in which the criminal legal system targets unhoused people, to the ways in which criminalization causes housing loss, and then housing insecurity itself causes reincarceration. So we're thrilled to be able to share that with you in the coming weeks, as well as the recommendations in that report to try to break this incredibly damaging cycle. So with that, I will turn it over to my colleagues to close.
Well, folks, race, color, national origin, religion, sex, family status, meaning families that have kids under 18, disability. These are the protected classes under the Fair Housing Act. Remember, as you heard, executive orders cannot change congressionally passed statutes like the Fair Housing Act, like the Voting Rights Act, like the American with Disabilities Act, or Title VI of the Civil Rights Act, and others. I want to thank you for joining us for this Fair Housing Month and Second Chance Month as we explored just the tip of the iceberg, folks, when it comes to Fair Housing Act protections. It's really important to remember that our communities flourish when we are all able to thrive, no matter a person's background or blemishes in life that they've overcome. But our collective ability to flourish comes at a price. And that price is making sure we vote, making sure we hold elected officials accountable, and ensure the right to vote for every eligible voter so that they can secure their vote and have that vote recognized and counted. Now, the newly introduced bill called the Save America Act threatens that right. Because I want to make clear here, because some people are thinking that the Save America Act is simply a voter ID law and everybody has a driver's license, so what's the big deal? That is not true. It is a law that requires people to prove their citizenship by digging up their birth certificates, I don't know where yours is, or by purchasing costly passports that many people don't have. These costs to buy a passport essentially take us back to the 1960s, which is before the Fair Housing Act and before the Voting Rights Act, to a time where poll taxes were put upon Black voters. But now poll taxes have long been outlawed, but here we are today. And just like those community members who fought to get the Fair Housing Act passed back in 1968, you too can do your part to help stop this regressive bill by calling your senators and telling them to vote no on the SAVE Act. To reach them, all you got to do is dial 202-224-3121. But before I go, I want to thank Barbara, I want to thank Leslie, and I want to thank my colleagues for their work and for joining us today. And I want to thank you. Thank you for joining me today. And let's all give a huge virtual clap of thanks to all of the current and former HUD staff members who have been working to ensure that the Fair Housing Act and other civil rights laws are properly enforced, and that HUD programs get the right compliance attention that community and residents deserve. Hand clap. Back to you, David.
It's going to be hard to follow up. Thank you so much, Demetria. And again, thank you so much for joining us today for this incredible webinar, Opening Doors, Fair Housing and Second Chances, for both Second Chance Month and Fair Housing Month. I also, just to echo what Demetria said in that call, we really want folks to be engaged at state and local level and at that national level as well. I know national politics often dominate some of the rhetoric that's going on, but we really want folks to be engaged at the state and the local level too, because there's some great things that can happen at the state and local level that can protect people from that federal overreach that we see happening right now. So we really want folks to be engaged. I'm also just in the chat going to put LDF's website where you can follow along and follow some of the amazing things that LDF is doing as well. And then we're also going to be, also just want to highlight, if you go to that website, that we also have some of the former HUD guidance that we talked about that's been rescinded, or it's not rescinded, but withdrawn by HUD. So you can still access those documents so that you can, again, know your rights and know everything that is going on. So again, we want you to stay engaged with everything that you have, and want to thank you so much for coming to this webinar. And with that, we are going to end it there. But again, thank you all so much for being here. And we really, want you to go out there and again, continue to be engaged, and continue to tell your neighbors again that this is both Fair Housing Month and Second Chance Month, and that with together, we can definitely make a difference. And so thank you all so much for being here.